Anything else on this issue in terms of testimony?
Not in terms of testimony, Your Honor.
Mr. Martinez, do you have any witnesses in terms of testimony? Are you prepared to argue?
I am, Your Honor.
All right.
Your Honor, I guess the state should proceed. It's his oral motion to oppose admission, so unless you want me to proceed.
Mr. Martinez, sure, the state's position.
Basically, what the defendant is asking the court to do is to take a look at what is clearly a dog and say that it's a person standing there. That's what I saw when I was looking at the photographs. And if I can stand here and ethically say that, then really what we have here is a situation where we have another sort of fantastical kind of type of evidence that is being asked to be presented to the jury. One of the things that we need to ask, and as the court probably knows, is whether or not this expert's technique or theory can be or has been tested. There's no way that we can test what he sees because that comes straight from his eyes and then he draws some of the lines. I will avow to the court that what I saw was a dog. I saw some ears and then I saw a snout. So it cannot be tested. We cannot, for example, like a drug test or a blood test, we can't submit it to somebody else for verification. That can't be done. The issue also is whether or not this technique has been subject to peer review or reliability. And the problem here is the reliability of what he is attempting to present to the jury. Again, it's the state's position that if we got 10 people to look at that without telling them what they thought it was, that 10 people would come up with something different. And so this proposed evidence is not reliable. In terms of this test again, and the reliability is what is the potential rate of error? In other words, if 10 people look at it, how many of those 10 people will think it's a dog? How many of those 10 people will think it's a gopher or any other sort of animal? We just don't know. There is nothing that has been presented by the defendant that indicates that there is any statistics with regard to the rate of error. And again, he talks about his lab and how he's looked at it, how the resolution's a little bit higher, but what are the standards or the controls that he uses such that we could take a look at those, we could apply those, and then say, this is exactly what everyone would look at. And I keep going back, for example, to maybe a blood test, maybe a test for cancer. Those are the ones that can objectively be verified. This is a subjective test, if you will. And if you have a subjective test, then you're going to get subjective answers. And there was no testimony that's been presented that this approach has been accepted in the scientific community. It is the state's position that this is really voodoo and that, as I said, as soon as I saw that and they put it up on the screen and I thought, well, that's a dog. And I can tell the court, if we take a look at exhibit number 4, that what I saw, these right here were the 2 ears. If you take a look at it, here's the mouth and here are the eyes. This looks like it may be a stick that the dog has in its mouth. So if I can make those avowals, and quite frankly, that's exactly what I thought as soon as I saw this, then there is nothing scientific about this. This is just an individual who wants to impose his views on the jury. And the jury can look at this. If they want to present the enhancement without his testimony about what he sees, or if they want to just present this enhancement and say, take a look at it, I can understand that they can do that. But in terms of his ultimate opinion that there's a person standing there and that sort of thing, I don't think that they've carried the day. And I know that this individual has talked about Daubert at least on 2 occasions when he was testifying, but he's not a lawyer and he really doesn't know what he's talking about when he speaks about that. So I would ask that the court preclude this evidence. Thank you.
Mr. Neri.
Your Honor, throughout the course of this trial, we have seen numerous text messages and emails that counsel for the state at one time avowed didn't exist. We've seen hundreds of them. The same voice that tells you that these didn't exist actually stands before this court and claims he sees a dog. That's the standard. Mr. Martinez says, hey, I see a dog, so this isn't admissible. That's not the standard. What Mr. Martinez sees or what skewed view he wants to take of reality is not what's before this court. What's before this court is whether the work that Mr. Neumeister did was scientific, within the field, and in generally accepted terms. This is science. Mr. Martinez takes a limited view of science, saying if it's not a blood test, if it's not a cancer test, if you can't do something definitive, it's not science. Well, that's just not true. But soon, Mr. Martinez will bring a psychologist up and talk about her work. Well, it's the same, right? It's not this definitive test. So this misguided and, shall we say, altered view of what now is science and what is not science that the state is taking is just that, misguided and based on a desired outcome. The fact that this evidence is adversely probative and damaging to Mr. Martinez's position and the state's position doesn't mean that it does not meet the Daubert standards. And that ultimately is what the argument Mr. Martinez made was. Mr. Neumeister testified that he used the computer software that is commonly used in his field to enlarge this photograph. He talked about working with the developers. He talked about working with other experts, and that they all use this Clear ID software. Mr. Martinez, in his argument, evaded that reality. There is no doubt about the fact that and there has been no dispute, there was no questions of Mr. Neumeister regarding challenging what he did. There was personal character assassination, trying to claim his expertise was invalid, but there was not actual evidence disputing, and the state has not put on an expert disputing what Mr. Neumeister did. Now, to some degree, the state has said, well, they can show the first three pictures, but, Mr. Martinez is afraid of the bite in this dog, I guess. But what we have here ultimately, Your Honor, is two alternatives. Ms. Arias has a due process right to present the best evidence available to the jurors. I see two alternatives. The court can preclude this photograph with these marks on it, which are merely traces, not enhancements of the photograph, mind you. But if the court were to do that, then the alternative would be to bring the jury up to Mr. Neumeister's lab and have them look at the photograph without this trace. As a matter of fact, if the court was inclined to preclude this photograph, I would say the court should do the same in a Daubert hearing, because that is the only way it's going to be able to see the validity of this outline. I've seen it, I understand it, I've been to the lab, and this is merely a trace of what is visible when we have the proper equipment. So, Your Honor, what I would say for the ease and the logistics of this case, what we have here is a scientifically valid results from the enlargement of the video. What is demonstrated to the jury with this outline is merely something that they could otherwise not see because of the equipment limitations of this courtroom. So again, under Trombetta, Ms. Arias has a right to present a full and complete defense. There has been no argument that this is scientifically invalid other than merely bluster. The reality before the court is the two alternatives are there. It's either this photograph or what we see in Exhibit 4, or it's bringing the jury up to Mr. Neumeister's lab. Based on the science of it, based on the logistics of it, we believe that all the photographs 1 through 4, should be admissible in front of this jury.
Mr. Nurmi, under Rule 702A, the court must find that the knowledge your expert intends to testify about will help the trier of fact to understand the evidence or to determine a fact at issue. What is your position with regard to Exhibit 4 and that requirement?
Well, to answer that question, I would go back to turning the court's attention back to 159. Because Exhibit 159 is a series of photographs that, whether seconds in time or minutes in time, depending on whose theory of the case one wants to accept, was a photograph taken. The testimony of Miss Arias was that she was indeed taking a photograph of Mr. Alexander exactly in the way that this picture depicts. It shows the flash, obviously, in the middle. Mr. Neumeister testified to that, the flash near the middle of the body. And it demonstrates that she was, in fact, holding the camera in the way that she dictated. This photograph also shows, or Mr. Neumeister's work on this photograph, and the reflection also shows she's got both hands on the camera and she's a couple feet away. It completely supports her testimony as to what happened that day. That's how it would assist the trier of fact, because it relates to where her hands were. No knife in their hands. No, just a camera. And in fact, that she was a few feet away. So that's how it helps the jury understand the testimony and the evidence presented. And there have been many of attack on Miss Arias' credibility, and this demonstrates exactly, verifies that she was in fact telling the truth. That's how it assists the trier of fact.
All right, thank you. Mr. Martinez, anything else?
Just to note that I don't see a camera, I don't see a knife, I don't see anything other than a blotch. And if we went to his place of business, I know that I said that I saw a dog. It looked like a German Shepherd, perhaps. I would probably see a Mexican Chihuahua. That's the problem with this particular evidence. It doesn't show anything, and it's subject to interpretation.
All right, thank you. All right, I do not have the comments to Rule 702 as amended in January, and I want to review those comments before I rule. So at this time, I will hear argument on the other motion, if you're prepared.
Judge, I have one misconduct motion.
Yes.
I have one bit of evidence that I'd like to play for the court as it relates to. And for the record, I was just handed this morning, just before the proceedings began at 9 o'clock, the state's response to motion for mistrial. I have reviewed it. One of the claims made is that Mr. Martinez is claiming that he did not intimidate witnesses himself inside the courtroom or directly. I would like to play for the court an interview that Mr. Martinez conducted with Dr. Samuels prior to his testimony marked as Exhibit 3, if I may publish it for the court.
And Judge, what I would object on the grounds of relevance, that has nothing to do with whether or not the jurors saw Mr. Martinez signing any autographs or whether or not the jurors saw the taking of the photographs. That's the purpose of the motion that we have here. If he wants to discuss the other motion, then we can discuss that too, but let's discuss one thing at a time so we can get a specific ruling as to the first motion. If he wants to talk us to the second one, we can do that.
Mr. Nurmi, the relevance of this particular piece of evidence.
Your Honor, it is all one in the same. We filed a motion for mistrial for prosecutorial misconduct, the inability to provide effective assistance of counsel because Mr. Martinez has engaged in behavior imitated by those, and some of it is in sealed proceedings, but imitated by those following the trial to harass and intimidate witnesses. And this interview that he did with Dr. Samuels is audio evidence of him intimidating, attempting to intimidate Dr. Samuels as he did Ms. LaViolette in chambers. So that's how it's relevant. And I thought that's the evidence the court wanted to hear or the motion that the court wanted to hear evidence on at this time.
Judge, I would ask for a ruling first on the one where Ms. Wong testified, so that we could at least, because I know later on there's going to be issues as to morphing or mixing these two. So we could address that one first, and then we can address the other one.
All right, let's argument on that motion for mistrial, Mr. Nermy.
Well, Your Honor, and I will preface my comments in that regard by saying this. Obviously, we know the prosecutorial misconduct is a cumulative issue. So it talks about, it relates to the infesting of the proceedings with general unfairness. One of the things that I talked about, and one of the things as the state mentions in their motion, numerous motions for mistrial. The state has thrown evidence, he's thrown his pen, he's yelled at witnesses, and we won't go into the intimidation of witnesses, I guess, at this time, but this is certainly a precursor to that same motion. And as it relates to this motion, he chose to walk outside and sign autographs and pose for pictures. This conduct, fortunately, based on what we've learned, was not viewed by any of the jurors. But we know that the previous conduct was. And as the state even implies in citing Aguilar and Poole, improper purpose, indifference to a significant resulting danger of a mistrial. He's standing out there having a fan club meeting. You know, putting aside the unprofessionalism of that, this sort of behavior does in fact, and is in fact, igniting a mistrial in this case, is exciting the fact that this kind of behavior is exactly what has led to witnesses being intimidating, because he is, you know, the great one, and he's out there signing autographs. And this infuses the trial with unfairness, and it is grounds for a mistrial when we consider every other item, every other action that he has done that has preceded this, including avowals of seeing dogs and text messages didn't exist. It's all one and the same, Judge. It's hard to separate it out, as try as we must. It is one big continuum of misconduct that has began from before this trial. It has proceeded to date, and I'm sure it will continue onward.
Mr. Martinez.
We are talking about an isolated incident where the prosecutor walked outside and people came up to him and requested specifically to have a cane sign and requested that he pose for pictures. That's what we're talking about. Somehow the defendant wants to connect that with everything else that the social media does. What the social media does, what the media does, that's not something that can be visited upon the prosecutor. That is something that is not connected. They haven't shown a nexus, any connection between what the prosecutor did on one occasion, something that clearly was unscripted, clearly was unanticipated. And so they want to say, well, that's something that affected the jurors. And that's how this case actually, or this issue actually was raised, that it affected the jurors. When we discussed this with the jurors, of course, we know that they weren't. And so defense counsel still continues to grandstand about this particular issue and attempts to piggyback other things to it. We knew, even before Ms. Wong was called, that the jurors were not affected. We knew that going in. And so rather than take the avowal of counsel that she saw nothing, we then go, and even if she had seen something, the jurors had already indicated that they hadn't seen anything. So instead, what do? We waste the court's time. We waste the prosecutor's time. Basically, we just come in and waste time. And that is an ethical issue. If it's an ethical issue, it's an ethical issue for the defendant, because they know that the position they are taking taking is spurious. And if we remember how this started, they were indicating that jurors actually saw Mr. Martinez. That's how this started. So when we start talking about all these other issues, they cannot then be included here. And so noting that there's this, if you will, ethical, unprofessional type issue on that side, because basically what they're doing is wasting everybody's time, then that's problematic. I say it's a waste of everybody's time, except maybe for defense counsel. Perhaps they could add a couple more pennies to their kettle that they have.
Anything else, Mr. Nerney? With
No,
regard
I'll
to
just note
this
the
motion.
improper argument as it relates to counsel. I'm sorry that our interest in fulfilling our duties as counsel and protecting Ms. Arias's rights interfere with his desire for stardom. But based on everything we've seen in the case law, and again, we will supplement later on, but I believe mistrial is the appropriate remedy at this time.
All right, the court has considered Exhibits 1 and 2. I've considered the testimony of Ms. Casares and Ms. Wong. I've considered the information provided in the sealed proceedings during which each of the jurors were questioned regarding whether they saw Mr. Martinez in front of the court building. And all the parties and defendant were present during that closed proceeding. The law provides that to prove prosecutorial misconduct, the defendant must show first that the state's actions were improper. Setting that aside, I'm going to go to the second showing that must be made, and that is that there is a reasonable likelihood that the misconduct could affect the jury's verdict, thereby denying the defendant a fair trial. In this case, there is no evidence that signing autographs and posing for photographs under these very limited circumstances could affect the jury's verdict since there were no jurors present. Mistrial is the most dramatic remedy for trial error and should be granted only when it appears that justice will be thwarted unless the jury is discharged. The court cannot make that finding, so the motion for mistrial is denied. Now, with regard to the next issue, Mr. Nerney.
Yes, Your Honor. I should probably have this remarked as Exhibit 1 of the next proceeding, next mistrial motion. Your Honor, it relates to the mistrial motion related to inability to provide effective assistance of counsel. I would refer the court back to, we had some sealed proceedings in which Mr. Martinez attacked Ms. Violet. During her testimony, these took place while she was still on the stand, attacked her for her response to someone who had threatened her. And I will not go into the specifics because they are sealed, but I will also refer the court, and I've published what has been marked as Exhibit 1, the copy of the interview the state conducted with Dr. Samuels. Before his testimony, this was provided to by the state, provided to the defense by the state. Your Honor, if we could, for some reason, the audio file is coming up with JPEGs in the system. I was going to have Mr. Newmeister play it through his laptop.
Yes.
Today's date is March 14th, 2013. My name is Paul Martinez. We're going to do interviews. What is your name, sir?
Dr. Richard Samuels.
And, sir, I noticed that you indicated that you finished your study on this case in June 21 of 2010. At least that's what your report says, right?
That was the time that I completed my report.
Right. Okay. Well, it says you're studying it. Right. And I noticed that you went back in December of this previous year to speak with the defendant.
Yes.
If you had already finished the report and you were done, why were you visiting her as late as December of last year?
I seem to recall that she was feeling kind of depressed, and I think we had seen some additional. I don't have the dates in front of me, so you have to excuse me. I'm just trying to.
December around before Christmas.
This past Christmas.
Right.
I think that may have been related to that new material that came out of that drive. That I sort of got a whole bunch of materials, pictures, photographs, I think some text messages or some such thing. That, given the fact that she was kind of feeling down, it was decided that I would go and spend some time talking to her.
You said that she was feeling down and you were
depressed.
And you were there to talk to her about that? Or?
Well, amongst other things, but my goal was to question her about some of the pictures that were...
Right, but you said she was depressed, and that's something that you also talked to her about.
I don't remember spending a lot of time with it, but because I didn't find her as depressed as I thought she might be.
Did that have anything to do with this presentation involving this instrumental versus expressive homicide?
No, not at all.
When did that come about?
Well, it comes about from the very beginning.
Do you remember when we had our interview
started preparing to testify, and I had a
Hey, hold on, because I only have a short period of time.
Okay.
When did you begin to prepare to testify?
Several months ago.
And that's when these words popped up a couple of months ago.
Yes, well, they
Thank you. Like I said, no, this is my interview. You can interview at your leisure.
I'll ask him questions at the end.
Okay, so this was a couple months ago that this came out.
Maybe it was like 4 or 5 months ago.
When was it? I'll let you tell.
I don't remember exactly. I have to look at my appointment calendar. I don't recall the exact date.
Okay. And you started talking about this as why did you start talking about this when you hadn't talked about it in your report that you provided?
Well, I mentioned the fact in my conclusion that I did not believe this to be premeditated based upon the fact.
But this is not what we're talking about. We're talking about what's instrumental and expressive.
Well, in order to explain how I came to that conclusion, I began to study more in depth the issues about homicide and types of murders, and I came up with this research, which I felt would be good for me to educate the jury.
And so you came up with this research involving premeditated murders, what you're talking about,
Yes.
right? And this helps explain what is a premeditated murder.
No, it explains why it is not a premeditated murder.
Okay. It talks about premeditated murder, right? And in your opinion, this explains why it is not a premeditated murder.
That's correct.
This issue, these terms, instrumental, where did you get them from?
Commonly from the literature, of which I've included several different
I understand that, but if they're common, why didn't you use them in your report?
Well, because I wasn't planning for the defense. There's just a certain amount of time that you can put into every report. When they're then prepared for a testimony, the further research is generally done.
All right. And as I understand it, instrumental is equated with premeditated.
That's correct.
And expressive is equated with non-premeditated murder.
Yes.
And you're prepared to discuss premeditated versus, and I know that the term is instrumental versus expressive, but I'm going to go with the other terms. Mm-hmm. And you're going to discuss premeditated versus non-premeditated murder.
If given the opportunity, yes.
Right. But that's what these two terms refer to, right?
Yes, that's exactly what
Right. And so one, for example, instrumental talks about what research has said is a premeditated murder.
Yes.
And the other one talks about what expressive being what is not a premeditated murder.
It correlates with certain characteristics and personality.
Right, but it talks about what is not a premeditated murder, right?
Part of the conversation, yes.
Right. And there's different types of crimes research that again goes to this issue of whether or not it's premeditated or not premeditated, correct?
Yes.
This dissociative amnesia, is that something that we talked about? Is that associated with the PTSD that we talked about previously?
PTSD, correct.
Right. In other words, what are you talking about when you say dissociative amnesia, and how is that linked to this post-traumatic stress disorder issue?
It's related to her inability to recall the details of the crime.
Okay. And what is dissociative amnesia?
Dissociative amnesia is an amnesia caused by psychogenic factors. It can also be caused by some physical factors as well. But we know that a significant percentage of people who commit crimes, especially homicides, experience amnesia. And that's due to the intensity of the crime. In fact, people who experience trauma, so a significant percentage will not remember the details of the trauma.
But in this case, you reached that opinion that she may have had amnesia. Is this a result of the testing, or is this a result of you talking to her? How did you reach this opinion? What steps did you take to say she has this dissociative amnesia?
Well, my testing revealed that she suffers from post-traumatic stress disorder.
What testing?
The Milan Clinical Multi-Axle Inventory and the post-traumatic stress scale.
There are no other tests that you've given?
No.
Okay. And those are the ones that indicate that to you that she has PTSD.
Well, I also compared her symptomatology with the diagnostic criteria from the DSM.
Correct. Is it DSM-4 or something, TR, or was that what it's called?
Yeah.
Okay. And then, so this right here, this amnesia, is something that's related to the post-traumatic stress disorder that you and I talked about.
Yes.
Previously.
Yes.
The stressed hippocampus, whatever that is. Hippocampus. Whatever that article, what is that about?
That explains how the memory capacity is distorted and actually will shut down under conditions of extreme stress, which I indicate she experienced during the commission of the crime.
And this stress that you say that she experienced, that's based on what she told you, or is there anything else that I'm...
Well, based upon the characteristics of the crime scene and what she told me.
Okay. This issue involving for example, the post-traumatic stress disorder, do you feel that you need the statement from the DSM-4 TR up there in order to explain what PTSD is?
Well, I didn't prepare a slide to that effect, but I
know you didn't. I
could.
But
I have the book. We could put it under.
Right. But what I'm saying is, in order to explain PTSD, you didn't prepare the slide, so you don't need it, is my point.
No, I can verbally describe the characteristics.
Well, what makes these other things that you have here, amnesia and crime-dissociative amnesia and all of that, what makes that any different? I mean, honestly, you could also describe that without resorting to the articles, correct?
Well, I'm bringing in material that may be unfamiliar to the jury.
I understand that, but you could explain it to them, right?
I could explain it to them.
Sure, just like you do with your ultimate opinion that she had PTSD, right?
Yes.
Okay. With regard to this Time magazine article, I mean, it's relatively new. I mean, January 20th of 2013, right?
Yeah.
And I mean, it's just anecdotal, isn't it? I mean,
and that's how it's presented. It's presented as an anecdotal presentation, basically to illustrate that this is a fairly common phenomenon, even by someone who's experienced in dealing with such types of stress. And then I was going to explain the physiological changes that occur in the brain when people are under stress and why memories are not formed as a result of that stress.
And I guess my point here, and my question to you is, you don't really need the article to say, well, you know, many instances, and you can cite whatever instance you want involving X that indicate that under extreme stress, this is what happens. I mean, you don't need these Time magazine articles to explain that, do you?
Well, I've always found that in presenting data to a jury, it's easier to use an audiovisual means when possible.
I understand that, but you can do it. I mean, you told us that PTSD, which is very complex, that you can explain that to them. What's so difficult about explaining the story, which is really what we have here, to the jury? I mean, this is a story about a cop or something. I didn't read it, but isn't that what it is?
Yes.
I mean, so what's so hard about explaining, what's so difficult about explaining a story involving a cop to the jury?
It's not difficult. It's just that we live in the 21st century. We have these methods available to us, and I believe strongly that when teaching students or teaching a jury, that it's better to have multimodal exposure.
Right, but you could do it, couldn't you? I mean, you could just get up there and say,
a blind person can run the bases too under certain conditions.
Sure,
you don't have to.
And we don't care about blind people, do we?
I do care about blind people.
You care about blind people as it applies to Jodi Arias?
I care about blind people.
What does a blind person have to do with Jodi Arias? Tell me about that.
Are you serious?
Yeah, you're the one who... Did I bring it up or did you bring it up?
No.
Who brought it up? Let's get to that. Who brought it up? Me or you?
I'm talking about...
Who brought it up? Me or you? You're here to answer my question. I did bring it up. You said that even a blind person can run the bases, right?
But this is on tape.
Right. So that has nothing to do with this. I want us to get back to this case.
Go back to it.
Right.
I just used an example.
Right. And I'm saying that you can explain it. Can't you?
Yeah, I can explain it. I can explain it.
Sure. This is just a story that was of something that was published in Time magazine, right?
That is correct.
The same thing with the cross-section of the brain.
No, that's different.
Well, no, let me ask you the question. Are you medically trained?
I have a degree in biopsychology, and I have written 2 chapters in a book on brain training, which includes physiology. I have taught physiological psychology to undergraduates and graduate students over the years. I have taught medical students about the functioning of the brain. I am not a MD.
So do you have a medical degree? The answer is no.
No, of course not.
Okay.
PhD.
Okay, and with regard to this issue of the cross-section of the brain, it appears that you have some study involving that, right? And you're familiar with it, right?
No, I'm trying to explain to the jury who's
That's not my question. I'm talking about your experience and what your training is.
I'm answering it. I use that diagram whenever I lecture about the brain.
Okay.
And
That's not what I'm asking you.
I'm afraid I don't understand.
Okay. You indicated that you have a lot of training and education involving this issue of the brain, right?
Yes.
And so you're conversant in that area, aren't you?
Yes.
And you've lectured on it, right?
Yes.
So you don't really need a brain up there to explain it to the jury, because of all your training and how well versed you are, you can explain it, right?
A picture is worth 1,000 words.
I understand that, but can
I can explain it without a picture.
That's all
without
I want to
shortchanging the jury.
I understand that that's your view, but you can. The issue is whether or not you can explain it.
I can.
Okay. I think I'm done with the interview. Thank you.
Before I hear argument, counsel, please approach. All right, oral argument on this motion, Mr. Numi.
Judge, in addition to the record we just made in the record, and if I might, I would seek to move, and I believe I did before, Exhibit 1 that was just played for the court into evidence.
For purposes of this proceeding only, Mr. Martinez, any objection?
No.
Exhibit 1 will be admitted for purposes of this proceeding only.
What we heard moments ago as it related to the other misconduct motion was we heard, oh, the prosecutor can't be tied to anything. It was just some inadvertent, unscripted sideshow, if you will. But here what we have, what we've just played for the court, is Mr. Martinez interviewing Dr. Samuels before he testified, questioning, trying to assert, and or what I would more properly say is bully Dr. Samuels into presenting the evidence in the way that the state wanted the evidence to present. That sort of bullying is improper. The defense, the state doesn't get to decide how Ms. Arias presents its case. The fact that adversely probative evidence is going to come in and is to the state's disliking does not mean that the state, counsel for the state, is entitled to come in and bully Dr. Samuels about the way that he wishes to present the evidence, demonstrate the evidence, yelling at him, leaning forward, and it's not reflected in the tape, leaning forward, yelling at him about, well, you could present this without this, you could present this without that, because that's the way the state wanted the evidence presented. He's not in control of that. This, we heard out through the entire tape, how he wouldn't let Dr. Samuels answer questions. And then the coup de grace of misconduct, the epitome of it, if you will, starts yelling at Dr. Samuels about blind people and attacking him on whether or not he cares about blind people. And that there is no basis in reality for that. It is intimidating the witness. It is bullying. It did occur before Dr. Samuels testified. And that sort of behavior is improper. It can have impact on the testimony that Dr. Samuels gives, combined with all the other statements, and I want to be clear too, all the other things off the record regarding Dr. Samuels, that were in sealed proceedings, I should say, regarding Dr. Samuels, does show a pattern of witness intimidation engaged in by this prosecutor. And it is sufficient combined with everything else. And we're not talking about this in a vacuum. If this were in a vacuum, I probably wouldn't be here grabbing my pennies, as Mr. Martinez would say. But instead, this is a continuum of behavior, Judge, that began months before this case went to trial and has continued to date. The fact that we're 4 months into a trial cannot be relevant license for Mr. Martinez to say, I can do what I want because, we're not going to declare a mistrial this far into the trial. Intimidating witness, bullying witnesses, as he did with both Ms. LaViolette and Dr. Samuels. And this occurred over defense objection, both in the courtroom and outside the courtroom. All grounds for prosecutorial misconduct and all grounds for mistrial, Your Honor.
Mr. Martinez.
Initially, I'll address the two witnesses, Alice LaViolette and Richard Samuels. An allegation that somehow the state was inappropriate in questioning Alice LaViolette. That was in sealed proceedings. You were present. You know the circumstances. Nothing could be further from the truth, and quite frankly, it is heartening to the prosecutor to have the defense attorney make that argument and to have you present so that you could rule on their objections as the questioning went along and you could see the subject matter that was being addressed. So clearly, there was no prosecutorial misconduct. If somehow there's this allegation that she was upset about it, well then she should be upset based on what was uncovered at that hearing. And I think the court knows what I'm talking about. In terms of Mr. Samuels, we need to step back and take a look at how that happened. First of all, there's an ethical issue with regard to the defendant. Or the defense attorneys, I can't really properly say it's the defendant. Defense counsel, on the eve of Mr. Samuels' testimony, had a PowerPoint. This PowerPoint had not been disclosed to the state, and had the state not walked by and seen the first slide, there would have been an issue as to this being shown to the jury before the prosecutor had a chance to look at it. There was no disclosure. There was a violation of the rules there. Not only was there a violation of the rules, but there's an attempt there to gain a strategic advantage. So you can't look at this and keep pointing the finger at the prosecutor and then say, well, what we did was unethical, but only look at what the prosecutor did. So let's look at what the prosecutor did. During the lunch period, he was given his opportunity to speak to this individual. We all know how long the lunch period is. We know that these have to go as quickly as possible so that we can get to the issues that are being raised. And one can only say, thank God that there was an audio of this so that the court can actually listen to the exchange between the prosecutor and Mr. Samuels. There's an issue involving whether or not there's this comment about blind people. The prosecutor didn't bring that up. It was Mr. Samuels, as the audio shows, who was trying to be evasive. We do have a limited amount of time here, and his being evasive was something that the prosecutor called him on. You can hear the tone of the prosecutor's voice, you can hear the tone of Mr. Samuels, and you could hear the tone of defense counsel in there. They were raising their voice higher than the prosecutor. I'm sure we can conduct a test to see. So this issue about blind people was raised by Mr. Samuels. They also say, well, this could have an impact on the witness's testimony. Well, we could have a solar eclipse today, but that's not something that has been proven that Mr. Samuels' testimony was impacted in any way. For example, his failure, if you will, with regard to the PDS would not have been changed in any way, shape, or fashion, however the tone of the prosecutor was. He just, quite frankly, relied on a lie, and he was questioned about it. So I think the state believes it's fatuous to say that his testimony could have been affected. Additionally, the motion raises some issues that attempts to make the state responsible for how conventional media and social media cover this case and how the individuals are portrayed. The state does not have any control over any of that, and I think it's something that defense counsel constantly keeps, if you will, attributing to the state. One example that I can give you where the state has no control over social media is the defendant. There's been allegations that she's been tweeting, I think is the word. I don't have any of that, so I'm not familiar with that, but I know that I've been told that she's been tweeting through, I guess it's an acquaintance of hers, a female acquaintance of hers, and there are things that have been going out. So if we're talking about the flames of interest by the media, whether it's conventional or social, in this case, they're being fanned by the defendant herself. One can't forget that she's a witness in this case, and she's actually violating the court's rule about discussing her testimony. So if we're going to be looking at that, and quite frankly, as I think of it now, I'm asking the court to issue an order that she desist from that because, again, she has testified, she is discussing her testimony, and again, if we're going to talk about disparaging comments that are made, again, I don't have an account, so I don't know the exact words. I don't watch television coverage of this particular trial because I just don't, but I've been told that she indicates something about the prosecutor and how tall he is. This is the type of conduct that they're complaining the prosecutor is doing, but when you take a look at it, it's actually created by the defendant. And I've gone at length to go over that because there is this constant attack on the prosecutor about his conduct, about what the media says about him. What the media and the people out there choose to believe is up to them. I have no control over it, and it appears, however, that the defendant does have control and seems to be attempting to manipulate it. So I have my written response. I think it addresses the court's issues or the defendant's issues, and I ask the court to deny the defendant's request again for another mistrial. Thank you.
Your Honor, I'm sure the court's at least somewhat familiar with the shell game, right? You take the ball, you put it around, and you shuffle all the hats around, and you look for the ball under the hat. You change the game, you change the rules, you change the argument, right? And this is what has happened with the state throughout the proceedings this morning.